3, 2, 1 गो। देखो तो लाइव देखो जरा फोन मेरा, देखो देखो देखो, क्या मेरी आवाज आ रही है? एम आई क्लियर? फुरकान लाइव, लॉ विद फुरकान इज लाइव। गया तो फुरकान लाइव, लॉ विद फुरकान इज लाइव। गया तो फुरकान लाइव, लॉ विद फुरकान इज लाइव। Now let's understand the comprehensive guide for a law student in CPC. We will go point by point. Since we have already discussed the principle of res judicata, now we will go much deeper in this. Okay. Why there is a need of res judicata? So there is a maxim called res judicata pro vitae accepetur, means a matter a judge must be taken as correct. इसका क्लियर जो एम है, जो इंटेंशन है लेजिस्लेटर का, वो बहुत क्लियर है। वो ये कहता है कि कोई भी एक मैटर गया तो फिर उस पर दोबारा ना हो, मल्टीप्लिटी ऑफ लिटिगेशन को कम करना इसका मैटर है। ओके, नाउ हाउ इट इज कनेक्टेड टू पब्लिक पॉलिसी फंड ऑफ फाउंडेशन? दिस डॉक्ट्रिन इज फाउंडेड ऑन पब्लिक पॉलिसी कंसिडरेशन। इट प्रिवेंट multiplicity of the proceeding, ensure the finality of litigation and protect defendant and from the fictitious litigation. So Lord Coke also observed that interest republicate it sit minis lithum. It is in interest of the state there should be an end of litigation. That's why you see that how court, कैसे कोर्ट या कोई भी मीडिएशन की बात करता है, एडीआर की बात करता है, दिस इज नॉट कनेक्टेड टू दैट, बट द ड्यूटी, इट इज द ड्यूटी ऑफ द स्टेट to defend that part, to defend each allegation, right? And now what about the legal certainty? When we say legal certainty, there are 4 crore cases pending in the courts. What happened in that? So that's why if you give the break to the suits, or you will set some rules regarding res judicata, then there will be a legal certainty. Then you will know, okay, this case will go 4 years, 5 years, 6 years, 7 years, right? It will not come again and again. And there is also a constitutional validity about this, that in the case of Satyadhan Ghoshal versus Diogenes Devi 1960, the court held that the doctrine of res judicata does not violate Article 14 of the Constitution, as it apply equally to the all litigant, serves reasonable classification based on intelligible differentia. That the same was taken in the case of E.P. Royappa also, right? When this particular now I have received one payment of notes, just phone pay 201. Good. My notes is selling. You guys also buy. Yeah? Okay. Okay. Now what is the essential condition of res judicata? We have to understand this. Okay. The former suit decided by a competent court. मतलब अगर कोई भी suit किसी competent court से already deal कर दिया गया है, कोर्ट का jurisdiction सही था, टेरिटोरियल सही था, सब कुछ सही था, तो वो होना चाहिए, ये मस्ट भी है, ये कंपिटेंट कोर्ट होना चाहिए। अगर नहीं हुआ तो फिर शायद ये अप्लाई नहीं होगा। नाउ आइडेंटिटी ऑफ द पार्टीज, जो पार्टीज होनी चाहिए दोनों सूट्स में, वो सेम होनी चाहिए, सेम टाइटल होना चाहिए, दोनों में सेम टाइटल की प्रोसीडिंग्स होनी चाहिए। जो फाइनल सूट है वो डिसाइड होना चाहिए मेरिट पे, डिफॉल्ट पे, जुडिक्शन पे या नॉन कंप्लायंस पे of res judicata, which support the plea of essential res judicata. Identification of subject matter. These are what? These are what the essentials. Okay. First, the former suit must be decided by the competent court. identity of the parties, final decision on merit, identity of the subject which is right, cause of action has aroused. The cause of action should be the same, even if it framed differently. Suppose कोई case है उसको किसी और तरीके से frame कर दिया, but it's going into the same element, then it will apply there. And that matter which and there is also matter which heard and finally decided. The degree and the judgment has come already. That cannot be come. And that is the part of the constructive. What are you doing? Play on the phone, no? Yes, thank you. Okay. Matter heard and finally decided. And there should be identity of cause of action also. That कि वो same frame में होना चाहिए. Now come to the next part, which is the exception of res judicata. अभी ये समझ लिया, अब exception समझते हैं क्या होगा, कि आखिर कब किस पॉइंट पे exception नहीं लगेगा. ओके, जहां absence of territorial jurisdiction होगा, जहां pecuniary jurisdiction lack होगा, जहां कोर्ट कुछ ऐसा डिसीजन देगी जो बियॉन्ड इट्स ऑथोरिटी होगा, जहां पे फ्रॉड और कोलिजन होगा, जहां पे कॉन्स्टिट्यूशनल क्वेश्चंस होंगे. ऐसे केस भी सुप्रीम कोर्ट में आ चुके हैं जहां फ्रॉड तरीके से जजमेंट लिया गया. एंड द प्रिंसिपल दैट फ्रॉड वेटिएट एवरीथिंग, हाउएवर इट्स मस्ट गो विद द फ्रॉड फाउंडेशन ऑफ द डिग्री. And question related to the constitutional matter is also important here. In the case of Lalu Sarju Prasad versus State of UP, it said that when the public interest matter, fresh examination of such matter is needed. The question relating to the constitutional validity of the statute, fundamental right, can be re-guided, not standing with the previous decision. So when there is a constitutional mandate involved, then it's an exception of res judicata. And there is a consent degree. There is also a concept of consent degree. When degree and compromise may not operate as a res judicata. Means when there is a consent degree, when there is a consensual part, then it will be not, it will be considered as exception. Okay. And now the part is subsequent change in the law. Okay, if there is a law which was former tomorrow, something else, if the law has changed, the principle is, in this particular thing, it will be exception. Res judicata will not apply here. The law which is applicable at the time when it governed, it's a different. If the law has changed, this will be considered as exception for res judicata. Okay. And now subsequent acquisition of the jurisdiction means, suppose किसी ने कोर्ट फी पे कर दिया, ठीक है, किसी तरीके से उसका सूट डिसमिस हो गया, फिर वो करना चाहता है सब कुछ ऑब्जेक्शन वगैरह हटा के, he can do it, right? It is allowed as per the law. Guys, my notes are selling, so it's good to see that I have started my small try on YouTube to teach you. Yeah, let's go. खुद से बात करने की आदत होनी चाहिए. Now, what is res judicata and res sub judice? That's the critical distinction between two doctrines. We have to understand each and every point. Now, res judicata is mentioned in section 11 of CPC, which say applies after final disposal of former suit, and it's barred the trial of subsequent suit on the same matter between the same parties. And the principle is founded on public policy which prevent the reopening of the concluded case, because it will multiply the case and litigation. And now give me a second only. Now we'll understand res judicata and res subjudice, which already I have told you. Now go with the res subjudice. What it is? Okay. This principle prevents the conflict of decision between multiplying proceedings. When the suit is pending, there is a sub judice, means something pending. Judicata already done. Sub judice मतलब पहले, तो it is in section 10. Res judicata after, then it is in section 11. This is how you will remember everything, right or not? Now, the applicability is when the suit is pending, the trial is an absent, disposal is left, then what will can happen? Then no effect will come, right? No application will accept it. So basically, it prevent, and one more Ujjwal Jha has come to taken our course. That's great. I love it. Thank you, Ujjwal, if you're listening to me. Yeah, we'll teach you also. So it's present conflict and nature temporary stay. Suit can be proceed after disposal of former suit. Right? While res judicata puts a final seal on the matter, adjudicated it, res subjudice operate as a temporary halt to prevent simultaneous litigation of identical matters. So basically, ये res judicata एक final seal करता है जो already matter adjudicated है, but res subjudice operate करता है temporary halt, इसलिए ताकि बहुत सारे litigation एक साथ identical matter में ना चले. Did you get my point? That was taken into the point when the Mathura Prasad versus Dosibai case happened in 1970. And what is the critical matter? What is the critical distinction? And a court said in the case of Pradeep Kumar versus Raghuvan Kaur that the Supreme Court emphasized that the section 10 require pendency of first suit. At the time of second suit was instituted, while section 11 required the first suit have been heard finally and finally decided. The two provisions operate at a different stage and serve complementary distinct purpose in each other in preventing the multiplicity of the litigation. कैसे लगे आपको फुरकान वकील साहब? आगे बढ़ते हैं. अब आइए कि what is that territorial jurisdiction when we talk about? Place suing of territorial jurisdiction. So we will understand. General rule. What is general rule here? Suit must be generally be instituted in a court whose territorial jurisdiction the defendant reside. That's a general rule according to section 15. That the defendant जहां रहता है वहां पे cause of action हुआ है तो वहीं पे partly arise होता है. Right? And now section 16 say different thing. It's a immovable property. Suit related to immovable property. वहां जहां property situated है. And this is mandatory provision. जहां पे प्रॉपर्टी सिचुएटेड है वहां पे मल्टीपल जुडिक्शन है. अगर कोई पोर्शन लोकेटेड है वहां पे भी. देन फिर सेक्शन 17 बार करता है मल्टीपल डिफेंडेंट, वेयर जहां पे बहुत सारे डिफेंडेंट होते हैं, अलग अलग सिटीज में रहते हैं, अलग अलग जुडिक्शन में रहते हैं. लेकिन इस केस में सूट कहीं एक जगह होता है जहां एक डिफेंडेंट रहता हो, और ये चीज ऑल डिफेंडेंट को सर्व करना है कोर्ट को और कन्विंस करना है कि आप लिख के दो हमें, देन वी विल एक्सेप्ट इट. अब पार्टी एग्रीमेंट क्या है? पार्टीज में एग्री इन राइटिंग कि हम यहां, जैसे आप देखते हो कि बहुत सारे कॉन्ट्रैक्ट, राइट, व्हाट यू राइट, व्हाट यू सी इन द कॉन्ट्रैक्ट, दैट द लिटिगेशन और द कोर्ट विल अप्लाई सो एंड सो प्लेस, मुंबई, दिल्ली, आर्बिट्रेशन एंड ऑल, you see in the contract, right? What is that? That is the party agreement as per the section 20 of the CPC. Now in the case of Supreme Court ABC Limonade Private Limited versus AP agency, that held that the territorial jurisdiction is primarily for the beneficiary defendant and to prevent the harassment of distinct litigation. However, एग्रीमेंट अंडर 2020 क्रिएट एक्सक्लूसिव जुरिडिक्शन इफ स्पेसिफिकली वर्डेड। मतलब आप ऐसा समझो कि अगर कोई कंपनी है वो दिल्ली में है और वो अपना केस वहां बुलाना चाहती है, लेकिन अगर ये चीज ऑलरेडी वर्ड में बता चुका गया है, लिखा दिया गया है, देन व्हाट विल हैपन? देन जो एक्सक्लूसिव जुरिडिक्शन मेंशन है वही होगा। एंड नाउ वी विल अंडरस्टैंड व्हाट इज पिक्यूनियरी जुरिडिक्शन। See, there is a nonsense something going on. बहुत बददिमाग हैं ये लोग। I don't know. Are you listening to me? My video. You are listening to my video. Hey, क्या बात कर रहा है? तू क्या सुन रहा है? चलो एक कस्टमर तो है सुनने के लिए। आइए पिक्यूनियरी जुरिडिक्शन को समझते हैं। ठीक है, ये होता है कोर्ट की मॉनेटरी वैल्यू। ओके, नाउ पिक्यूनियरी जुरिडिक्शन इस चीज को रेफर करता है कि कोर्ट इंटरटेन करे बेस्ड ऑन द मॉनेटरी वैल्यू ऑफ सब्जेक्ट मैटर। ठीक है, दैट इज डिटरमाइंड बाय द स्टेट इनएक्नॉलेजमेंट कोर्ट नोटिफिकेशन, कि ये कहाँ कहाँ कोर्ट की जो हायरार्की है वहाँ वो इंश्योर होता है कि प्रॉपर डिस्ट्रीब्यूशन क्या होगा, किस कौन सा मैटर कितने के पास जाएगा, किस कोर्ट के पास जाएगा, कौन सा स्मॉल वैल्यू का मैटर कहाँ तक जाएगा। नाउ इसका स्टार्ट होता है वैल्यूएशन फॉर द कोर्ट फीस। ठीक है, ये आपको सेक्शन 7 to 11 में ये चीज़ मेंशन है ऑफ 18 कोर्ट फीस ऑफ 1870, जो कि ये बात करता है of a different type of suit. The plaintiff must determine the value of that it correctly affect the both court and the fees payable that the court pecuniary jurisdiction. Money suits value equal to the amount of claim. Party suits market value. Sir, I have bought. Who is this? Ujjwal. Now we'll take a break right now.